The United States Supreme Court just issued a major decision by an 8-1 vote. The court upheld a federal statute that temporarily disarmed individuals subjected to a domestic violence restraining order. You had Justice Clarence Thomas dissenting. I want to bring in Mike Sachs, senior advisor to court accountability and now also an advisor to MeidasTouch on all things United States Supreme Court. So welcome to the MeidasTouch Network. One point about Mike as well. He was a classmate of mine at Georgetown Law, so it's great to have you on the network. Can you break down the Rahimi decision as well as it in the context of the Supreme Court's other gun jurisprudence?
Absolutely. Thanks for having me, Ben. So Rahimi is, in essence, a cleanup on aisle originalism. Now, a couple of years ago, the Supreme Court issued a decision striking down a 100 or so old gun restriction in New York City, saying that any gun restriction across the land to be constitutional must have some analogous connection to restrictions that were in place either in 1791 when the Second Amendment was ratified, or 1868 when the 14th Amendment, which makes the Second Amendment applicable to the states, when that was ratified. And this is a history and tradition test that was vigorously protested by the dissenters in the Bruen case. That was the name of the case from 2022. After the Bruen case, a whole bunch of challenges came forward against various state and federal laws, to assault weapons bans, to bans on felons carrying guns, and also then to this one federal law that was at issue in this case. That was a guy who was under protective order for domestic abuse, domestic violence, wanted his guns back because the federal government said you can't have guns. And he said, that's against my Second Amendment rights. There is no history or tradition of people like me being stripped of our guns because back at founding or at Reconstruction, well, domestic violence wasn't a thing that was prohibited. And the Fifth Circuit, which is a very extreme right-wing court based out of New Orleans, which covers Mississippi, Texas, and Louisiana, said, you're right, guy. We look at Bruen, we look at this 6-3 supermajority decision talking about history and tradition written by Justice Clarence Thomas, and we agree you should get your guns back because there was no history or tradition of disarming people under protective order for domestic violence back then. Well, this was something this Supreme Court probably didn't anticipate coming back to them when they decided Bruen. And so today, in this Rahimi case, that was the name of the person who was trying to get his gun back, the Supreme Court by an 8-1 vote with the author of Bruen, Clarence Thomas, as the one dissenter, because the rest of the justices who were part of that supermajority in Bruen said, no, we don't want to touch this. This is bad optics. We don't want to look as though we're enabling domestic violence, people under protective order for domestic violence to continue their violence with a weapon, with a firearm. It was a pretty wild decision. As I said, it was 8-1. Chief Justice Roberts wrote the opinion, conducting cleanup on aisle originalism and distancing his right-wing supermajority on the Supreme Court from the even more right-wing majority on the Fifth Circuit, saying, no, we're not like those crazies. We're down the middle here. We're not going to give guns back to domestic abusers.